Hi, my name is Nathaly, and we're with Unicorn Properties today talking about personal brand and personal brand protection. We are with Ramon. He's our patent and trademark attorney for Unicorn Properties as we are working on that protection. I was curious to talk more about this because a lot of people in our community have their personal brands, but they don't know they need to protect it. So I thought it would be great to chat with you to understand, the importance, the risks, and anything like that. So if you don't mind sharing a little bit more about you and, how do you get into law and what makes you so passionate about patents and trademarks?
Absolutely. Well, first of all, Ramon Urteaga is my name. I'm a U.S. attorney. I've been practicing law for 18 years.
Oh, it's my age.
Even though I'm only about 25 years old, but 18 years. And it's been a really fun career for me. I own my own law firm.
Okay.
And I dedicate myself to patents and trademark, but also other areas of intellectual property law. Intellectual property is what encompasses all of these concepts: trade secrets, patents, trademarks, copyrights, which people normally hear about, but patents and trademarks are the focus of my law firm. And in the area of branding, generally, big companies go out of their way to protect their brands in many different ways through intellectual property. Copyrights are one subset of that, but a lot of times trademarks are the key to branding. And there are many ways in which trademarks, trade dress, and that entire framework of law can protect many different aspects of the brand.
So in the case for real estate, we have we wanted to protect our personal brand. How important it is for other realtors if the brand is growing, quite a bit, they're getting known around, not only their own city, but outside, countrywide or internationally. At least for us, it's very important to expand internationally. How important it is for them to protect it, like right now, instead before they get too big?
It is very important. It is important for various reasons. A lot of times people will ask me, well, I want to launch a new brand. Do I need to register my trademark? And I say, well, no, you don't have to, unless you're okay with your brand being copied by others, right, or imitated. So it is important to do it. And first of all, you need to come up with something that is somewhat unique, that differentiates you from other competitors in terms of the colors, the identity of the brand itself, the word, the slogan. Make sure that others in that space aren't already using it, because that can get you in trouble.
Like the red and the blue in real estate, right?
For instance, right. But assuming that you've already gone through all that exercise and you have in fact identified something that identifies you uniquely, then register it. Now, in the United States, if you get a registration, a federal registration, it will give you exclusivity over the use of whatever it is that you're protecting with your trademark. And I'll explain what I mean by that, across the entire country. So there are states that have also their own statewide registrations, but why do that? If you can get, instead of doing that, you go the federal route, then you get protection for the entire country and you exclude others from using your brand. And it doesn't have to be the exact same brand. It doesn't have to be the exact same word or symbol or logo. It could be something that the public might consider to be confusingly similar. So in the case of a logo that includes some colors, and then someone copies everything except for the color being slightly different, well, that is confusingly similar. So if you have a registration for one, you'll probably be able to lock or block the other competitor from copying or coming anywhere near your mark. But you can also do not only logos, but you can do colors. You could do an example in the US, UPS, which you've heard of. Of course, it's a delivery company for goods. And everyone knows UPS because their trucks are brown, chocolate brown. They are the only company in that space that is allowed to use brown. So if a competitor decides to use that chocolate brown for delivery services, it will be blocked right away, anywhere in the country. But beyond the country, you can, in fact, get an extension of your brand, of your mark, your trademark registration in other countries. There are different tools to do that. You can do it in 1 or 2 countries, or you could do it across many different countries. Naturally, the greater the list of countries, the more expensive it gets.
Of course.
Everything comes down to money, right? And especially if you need to involve lawyers in each jurisdiction.
Okay.
But you always need to look at finding the right balance between the risk and the value, right, of your brand, or how much do you care to prevent others from copying it or imitating it.
And what would be the process? Let's say that in the real estate space, an agent that is growing quite a bit and they want to register today. So they will be, Ramon, ready to go. What will be the timeline or the process they need to follow to start this?
Yeah, if you can register whether you have already started using it in commerce or if you have a good faith intention to start over the course of the next 3 years, right? Yes, you have the intention of beginning to use that mark, then you can go ahead and file an application. In the US, you can file an application for the registration of your trademark, but the government is not going to issue the registration and give you the final document that gives you rights until you can actually prove that it is in use.
Okay.
So if you already started using it, then of course you don't have to worry about that.
The date?
You go back to not the date of application, but the date of first use. Okay. You get exclusivity as of that date. Okay. So you get priority to that date, and the process will always depend on any potential objections on the part of the United States Trademark Office, Patent and Trademark Office, USPTO. If they issue objections because of likelihood of confusion, or if they claim that your mark is maybe descriptive, there's a number of things they can say, then that will lengthen the process, because then you have a number of months in which to reply. And if they don't buy it, then they issue another office action. It could get lengthy, but normally if it doesn't have those obstacles, we're looking at maybe a year and a half, more or less, between a year and a half, if so long as you can
prove. They tell you that you have your certificate.
Until you get that certificate, right?
And nobody objects.
And nobody objects, because that is a good point, because at some point during that process, the USPTO will publish your approved application to the public and letting everyone know that you have the intention of, or you're seeking registration, so that if anyone has any objection, any issue with it, then they have the ability to file what is called an opposition, saying, I am opposing myself to that registration because it might impact my business detrimentally. But that's only for about a month. If no one says anything after a month, then it goes to approval.
So nobody reads newspapers these days, right?
Right. Well, I mean, there are services that will monitor marks that are somewhat similar to yours, and they will alert their clients that Nathaly is about to get a trademark that is similar to yours. You may want to oppose it. Okay. So they don't need to necessarily be reading the paper.
Okay.
Yeah.
I see. So let's say like from the day that, let's say, we filed to getting a certificate, if nobody opposed, about a year and a half until you might get your certificate. Right. Nobody can touch it.
Right.
Nobody can.
Now, from the moment that you apply, or even before, once you start considering your slogan, your logo, a mark, then it is important to provide public notice in the form of, let's say, the TM if it's a product, or an SM if it is a service mark, right? So in the case of your mark, Unicorn Properties, SM would be the proper way of providing notice. Once you get the registration, which is that certificate that says, here, now you have legal rights, then you change that to the R with a circle around it, which I'm sure you've seen many times.
Yes, that's great. So then I think I would suggest, right, like to any person that has like an invention, a brand, personal brand that they want to take it to the next level or grow with it, to start now instead of later, because it does take quite a bit of time. And then if you get too big, there's maybe more people that want to probably battle you a little bit.
Earlier, the better in all cases. Now, if it's an you said invention, and that opens up a whole can of worms, because inventions now are patents.
Okay.
And that is a totally different animal, right? And for an invention, before you disclose it to the public or to your sister or to anybody else in a non-confidential manner, the second that you do that, you will lose rights to get an eventual patent in most countries throughout the world. In the US, the clock starts ticking, but you have a grace period of 1 year in which to file for patent protection. Once you disclose it, non-confidentially. If you have an invention and you're working with someone that is going to make a prototype or someone, a supplier maybe, that is on a need-to-know basis, then you can, but you should have an NDA in place, a non-disclosure agreement, or at the very least, a verbal agreement saying, listen, I'm telling you this because you need to know this purpose, but it is considered confidential information. You are not allowed to tell anyone.
Okay.
And best practice would be, in a case like that, to make a note of it for yourself. On this date, I told so-and-so about it, and it was confidential. Just make a record of it, because you may not see an issue today, but let's say 3 years from now, you finally get your patent. And then 5 years after that, you decide that somebody is infringing your patent, and you sue that person. So now you're looking at 8 years, could be 10 years down the road. Eventually, then your litigation, the opposing counsel will try and discover everything that led to the invention. And when the topic comes up of potential disclosures, if they were non-confidential disclosures, then boom, you're done. Your patent is declared invalid because you failed to disclose that fact that you had disclosed it non-confidentially to the patent office, etc. And then you've spent all this money, all this effort, all this energy for nothing in the end. So it is a very tricky situation when it comes to patent.
So when it comes to an app,
yeah,
would that be a trademark, copyright, patent?
It could be both.
Because we're working on an app right now.
Yeah.
We have disclosed for the developers, some of the features. It's pretty unique. But then I didn't keep a log of the NDAs, but we did issue NDAs. So would that be something, which category would that fall into? Is that technology, app, real thing?
Yeah, normally in the US, for example, when it comes to software, and that's what this is, an app is software. The software per se, you cannot protect through patents, you cannot protect through trademarks, you can protect it through a copyright. You can actually send the code to the copyright office and secure it that way. But from a patent standpoint, it is difficult to get a patent these days based on the state of the law, but it is doable. And normally what you patent is the set of steps that the app will carry out. So the app will communicate with this server, and the server will communicate with some other entity, and then that will do something to you, and then the interface with you. Each of those processes define jointly a method. That method is what you ultimately claim to be yours in the patent. But aside from that, you can also secure protection in the form of design patents for some of the ornamental elements of the app. Let's say if the interface of the app is unique enough, it's different from what's ever been done before, then you can probably get that design, the figures, the shapes, secured through a design patent.
Okay.
Which is easier to get than a regular patent, which is called a utility patent. But also, if you have any logos in the app or any slogans or anything like that, those are trademarks that you can protect through a trademark registration.
Okay, perfect. So then to recap, let's say, back to the beginning, what's the difference between patent, copyright, and trademark? How they're mostly used, to understand just a high level.
I have a 1 hour webinar coming up May 8th. If you're interested in attending, it's free of charge. It's about an hour long. And I actually go through that process of explaining the differences. So normally a patent protects an invention, which could be a process, a new method of doing something, or it could be a machine, an apparatus, a structure, a combination of elements. Those are protectable through a patent, a utility patent. A design patent protects the ornamental aspects of an article of manufacture. So the ornamental aspects of a bottle, the ornamental aspects of something, so long as it's not functional. A trademark acts more as a source of good. So it's a symbol, combination of alphanumeric characters, or it could be a figure or a combination of figure and words, letters, etc. So long as that is used by the owner of that mark to identify the source of the products, right? So Pampers uses the term Pampers for all of their diaper products and even some adjacent products that go along with the whole baby theme. And those are, that logo, that word is put there as a trademark so that the consumer, the public in general, can go to the store and say, okay, as a consumer, I don't need to bother with doing all this research. Is this product something that I can trust? No, it has the Pampers brand. I can trust the brand because I know it comes from the same source as all these other products that have the same name. So that's what the source of product is. A copyright is more of an artistic thing. Anything that has a certain level of creativity that is put on a tangible medium of some sort. Once it's recorded on some type of tangible medium, which could be paper, it could be a CD, or it could be a number of things. And a book, a painting, a poem. I mean, there are many things that can be copyrighted. Even product designs, like packaging designs, if it's artistic enough. One that I came across not too long ago was a series of, I believe it was the Energizer brand of batteries. They put some of their packaging for batteries with different color schemes as a registration with the Copyright Office so that people cannot just copy it.
For personal branding, would that be mostly in the trademark routes? Mostly because of the
Mostly it would be trademark because one advantage of trademarks is that so long as you continue to use it, you can renew it forever.
You have to pay
renewal fees every 10 years. And actually before that, at the 5-year mark, there are some other declarations that you need to submit to the Patent and Trademark Office to show that you are still using it.
Okay.
If you stop using your mark as it is registered, then you lose all further rights to it. It goes abandoned, it died, and somebody else can grab it. Yeah, a patent is a limited duration. A utility patent lasts 20 years from the time that you submit your application. And there are some adjustments that are possible, but that goes beyond the scope of what we're talking about. And then a copyright, it depends on the circumstances, but a copyright can be 75 years after the death of the author and whatnot. So there are different durations. A design patent lasts 15 years after it actually issues.
Not when it starts the process. Interesting. Awesome. So now that we know more about, protecting personal brands, it's very interesting that, you can reach out to Ramon directly if you have any questions about, protecting your personal brand, either in the real estate space or in any other industry. So we learned so much today. Thank you so much, Ramon. And you will leave your information in the description below.
Yeah, no, my absolute pleasure. Love to help small and medium-sized businesses with giving them cost-effective ways to protect their creative assets, right? What they have created is important to protect, unless you don't care that it is copied by others. But most people, I don't think, fall into that category. They do want to protect it. So give me a call or send me an email if you have any questions. And thank you for the opportunity.
Thank you so much, Ramon. We'll put all the information in the text below, and you can reach out to Ramon directly. I'll see you next time.
Take care.
Thank you.